Good afternoon, ladies and gentlemen. This is the Judiciary Committee for the Alabama House of Representatives. We have several bills we're going to take up today. We have some public hearings. We will not be voting on the public hearings today. We will carry those over for a week, and we will see about them at some point in the future. So, go ahead, Brady. Would you call the roll for us?
Hill.
Here.
Wadsworth. England. Here. Almond. Bedsole. Chestnut.
Present.
Faulkner. McClammy. Pettis. Here. Robbins. Simpson. Here. Standridge. Starnes. Here. Stringer. Here. Tillman.
Wadsworth's here.
Yeah, we have a quorum.
We got a quorum? Good. We have a quorum. First bill we're going to deal with, ladies and gentlemen, is Senate Bill 153. Senator Barfoot.
Thank you, Mr. Chairman. I know y'all are on a little bit of a tight schedule, so I'll just say this is a bill that I think passed the committee last year. We got to the House floor and we ran out of time. This gives the ability of a judge and a pretrial for supervision, for the judge to order that supervision pretrial. It is originally written to include all A and B violent felons. We thought there's an amendment and should be one coming Mr. Hawthorne is working on. I apologize that we didn't get that to you, that would limit it further from A or B violent felons down to just those individuals charged under a NISE law. The second portion of that is there's expansion to include community corrections as well as probation who could monitor those individuals. Again, this gives the judge the ability, should someone bond out on any of those NISE law offenses, to order that that person be supervised by pardons and paroles or community corrections pending the trial.
And I do have that amendment, Senator, and it's what it says. What you just said. It's a charge with Section 1513.3. Supervised by Board of Pardons and Paroles or an employee of Community Corrections. Is there a motion to adopt this amendment?
Due to the fact, and I'm not going to say this has anything to do with the fact that the Senate Judiciary Chair has a bill that the House Judiciary Chair is offering an amendment of, but due to that, I will offer to support the amendment to substance.
Thank you.
I'm not sure exactly what you just said, but okay.
I think it's a compliment.
I'm a first and he's a second.
Thank you.
Any questions about the amendment? All right, all in favor of the amendment say aye. Aye. It's amended. What's the other amendment? Mr. Starnes, don't you have one? Yes. Go ahead.
Yes, sir. The amendment replaces line 31 on page 2 with the following. The governor or it's otherwise becoming law and shall be operative upon certification by the Director of Finance that sufficient funds have been appropriated to the Board of Pardons and Paroles to implement this act.
Thank you. Is there a second? Second. Okay, motion and a second. Any questions on the amendment? All in favor of amending this a second time, please say aye. Aye. Any opposed? Okay, it's amended. Senator Barfoot, it's to you as amended twice.
Thank you, Your Honor, Mr. Chairman. I know Mr. Hawthorne is working on the amendment. I don't know if it's acceptable that way or not. I don't know if it needs to be a floor amendment, but that amendment, I believe, would limit from violent A or Bs down to a NISE law. The reason that is because we didn't want to overburden, at least initially. We want to see what those numbers are like at pardons and paroles or community corrections and what kind of numbers came to them or what kind of folks came to them.
Do what now, Rod? All right, tell you what, let's do then. I'll just withdraw the amendment. I'll withdraw amendment number 1. Is there a second to the withdrawal of that amendment? Second. All right, all in favor of withdrawing that amendment, say aye. Aye. All right, now let's go with the new amendment, Ray.
So again, Mr. Chairman, I believe that new amendment would further, as I said before, instead of the ability for violent A or Bs, it would be only those, I think, 12 or 13 offenses that are limited under Nye's law. And my apologies to the committee because I didn't have that amendment didn't get transmitted.
I will happily offer it. What this does is this says on page 1, line 24, where it says replace Class A or Class B violent felony offense with an offense in accordance with Anaya's law and strike lines 25 through 26.
Okay, so we will withdraw Amendment 1. And there's a motion and a second for Amendment 3, is that correct?
Do I need to make the motion to withdraw Amendment 1?
No, I did.
Okay, already done. Okay. Then I'll make the motion to adopt Amendment 3.
All right. Any questions about Amendment 3? All right, all in favor say aye. Aye. All right, Senator, it's now to you with Amendments 2 and 3.
And be glad to take any questions, if any.
Go ahead, Mr. England. Second. There's a motion and a second to give the bill a favorable report as amended. Any questions? All in favor say aye. Aye. Any opposed? Okay. Thank you, Senator. Appreciate it very
Thank you,
much.
committee members. Thank you, Mr. Chairman.
Thank you.
Sorry for the delay in having that ready.
Do what? Next bill is going to be Senate Bill 223. Mr. Simpson, you're going to carry this for Senator Figures, right?
Correct, Mr. Chairman. Senate Bill 223, what this does, it allows the child hearsay for a child victim who is less than 12. This would allow hearsay for a child witness of violent crimes who are less than 12. So it's already the statute that if you have a victim under the age of 12, you can testify via closed circuit television, you can testify certain child hearsay statutes that are there. This would allow if the child was able to see it was a witness to a crime, that they could testify through these same methods through this process.
Yes, sir.
Motion to give the bill a favorable report.
Second. Motion and a second to give this bill a favorable report. Is there any more discussion? All in favor say aye.
Aye. No.
Yes, sir. Bill's given a favorable report. And you got 224 too, don't you, Mr. Simpson?
I do. There's a string of just kind of figures going through some of these for the statute. For this purpose, we talk about incest if the victim is under the age of 17, for transmitting an obscene material to a child. For child victims in this statute is not defined. We're placing the age of under 17 into the statute. We're also distribution of a private image would specify the jurisdiction of the private images of where they can be prosecuted. So that way, if the victim is in one jurisdiction and the defendant's in another jurisdiction, it specifies where the prosecution, that they can prosecute in either or.
Any questions? Yes, sir.
I just had one question. What's the age now?
For
It's under 17. What is it changing from to under 17?
you're talking about for the incest portion?
Yes.
There's no age. This just defines a child to put, there's an enhancement if it's a child under the age of 17. So incest as it is in the code, there is no age requirement. This is just a push up if the child is less than 17.
Appreciate it.
Yes, sir. Motion for favorable report second. Okay. Any other discussion? All in favor of Senate Bill, giving Senate Bill 224 a favorable report, please say aye.
Aye.
Any opposed? Okay, thank you, Mr. Simpson. We appreciate it very much. Senator Singleton, you got Senate Bill 64.
Good evening, Mr. Chairman, committee. Thank you for letting me come before you. This bill is basically a bill for jury duty, for jury service, based on a cutoff of up to 75. I think the bill started out at 70. Had some other members wanted to raise up to 75 on that limit to where they could be excused from jury automatically at 75 years of age.
Okay. Is there any questions about this? Motion? Second, okay. There's a motion and a second for a favorable report. All in favor say aye.
Aye.
Any opposed? Senator, thank you.
Thank you, Mr.
Favorable
Chairman and
report.
committee. Appreciate it.
Mr. Starnes, are you going to carry Ms. Weaver bill? Sir? Sure. Then I'll take the next one, which is,
Judge Hill, you have HB 492. Can you explain the bill?
yes, sir. There's a substitute bill, but what the substitute bill does is it's a Judicial Privacy Act. Basically, it says that certain information of a judge or a judge's immediate family member can be excluded, such as home address, phone numbers, personal email, Social Security, driver's license, bank accounts, numbers, name of judge's child's daycare, school, license plate, photos. It is, and what the substitute actually does, folks, is it expands expands the definition of the news, who can how it's gathered, but it also expands it to federal judges as well as state judges. So it would make the privacy type of requirements applicable not only to state court judges, but federal court judges that could be handled in our state courts.
Is there any questions on the substitute? All in favor, give the adopting the substitute, say aye. Opposed? The bill is substitute. Do I have a motion? Second. All in favor of adopting the substitute, say aye. Opposed? Bill substituted.
Thank you. Appreciate it.
We got it. Do we not? We got to vote on the bill. Substitute. Bill gets favorable report.
Go ahead, Mr. Starnes.
Mr. Chairman, committee, Senate Bill 153 is a companion bill for House Bill 428, and that was under existing law. Child abuse is a Class C felony. This bill would define mistreat to include intentional behavior that inflicts unnecessary and unjustifiable pain or suffering on a child without causing physical injury to the child, and would expand the definition of child abuse to include willful mistreatment.
Yes, sir. All right, there's a motion, second for a favorable report. This is the same bill we just passed out of the House yesterday, isn't it?
Yes, sir.
Any questions? All in favor say aye.
Aye.
Any opposed? Bill gets the Senate bill gets a favorable report.
Thank you, Mr. Chairman, committee.
Okay, ladies and gentlemen, we've got a couple of public hearings. Mr. England, you want to talk about House Bill 382 and then House Bill 14, and then we'll have the public hearings. We're going to do both of them? Just one at a time.
So I'll do 382, then we'll have a hearing, and then 14.
Yes, sir. Yes, sir. I just thought while you were down there, you know, had some both with you. Oh, yeah.
Representative Faulkner asked me how many bills that I filed this session. I have a better question for him. How many of my bills did you put in subcommittee this session?
The last one got put on the floor
That's true.
of the House floor and got on through.
You're going to remind me that you're on the Rules Committee. I know you are. And I appreciate that. Thank you, sir.
Excuse me, just for a second. I've just got a text. Judge Carpenter, David Carpenter? Yes. Please stand up. Judge Carpenter is from the Bessemer Cutoff in Jefferson County. We are glad to have you here with us. We appreciate you attending our Judiciary Committee meeting. Thank you for coming.
Yes. He's in my district, Your Honor. And
What?
a fine judge to be in front of, too, Judge Carpenter. Stealing my thunder. Well, first bill up is 382. Thank you for the recognition, Your Honor. And members of the committee. The first bill deals with the crime of felony murder and adding a couple of sections to it and redefining a particular section. And I'm not going to speak to some of the specific instances why this is necessary, but I'm just going to give a general explanation as to what the bill does, and I'm going to let the individual that is here to speak on the public hearing give life to what I'm talking about. But the bill itself, if you look on page 3, lines 71 through 74, it adds a section or a line to section 3. It says a person does not commit murder under the subdivision if the person killed was a willing participant in the commission of or attempt to commit the underlying felony. And that is the crux of the bill. And oftentimes, as we create laws, there will have unintended consequences to those. And oftentimes, people that are criminalized and sentenced to very long sentences, the law really isn't intended to incarcerate those citizens for as long as sometimes it ends up being. So that's essentially an explanation of the bill. And like I said, I'll let Ms. Smith, who has signed up to speak to this bill, kind of give you a story that gives life to why we're here.
Okay. Yes, sir, you did. Sure.
Representative England, on page 3, up above, I saw the part that you referenced to, which I think you said would be the main kind of crux of the bill.
Yeah.
Up above that, you see where it says, why was it taken out or any other felony clearly dangerous to human life?
Because there will be, if we got a scheme or some sort of pursuing a common crime, right? And a crime occurs that doesn't necessarily threaten the life of another individual. It ultimately ends up with somebody losing their life. So it says, are any other felony clearly dangerous to human life? We're somewhat trying to restrict it so it doesn't include a bunch of different offenses, which would ultimately could end up with somebody serving a life without sentence that we weren't necessarily intended to ensnare. So, and again, I'm not suggesting that this bill is in its final form. There's also kind of all sorts of conversations that would need to happen, and we're going to have time to have those. And so, but the real crux of the bill is what I discussed with you.
Okay, and I think I have a Mr. Smith who wants to speak. Is that correct? Yes, sir. Ms. Smith, please come on up. And tell us your name, please, and where you're from, and so we get a little bit of introduction to you.
Okay, my name is Brontina Smith, and I'm from here in Montgomery, Alabama.
Okay, ma'am, go ahead.
Okay. My name is Brontina Smith. Like I said, back in 2015, my son, Lakeith Smith, and some of his friends burglarized an unoccupied home in Millbrook, Alabama. A neighbor saw suspicious activity, and she called the police. When the police came in, police shot and killed my son's friend, Dante Washington. My son was later, my son and his friends were convicted of the murder due to this Alabama felony murder law. And even though they didn't shoot or kill anyone, they were still convicted and given a lengthy sentence. My son was given 65 years initially. However, my son didn't kill anyone, and I do believe, and I say it all the time, my son should definitely be punished, but he should be punished for the crime that he committed, which was burglarizing the home. It's been 8 years now. My son has been sentenced to the most violent prison in Alabama. And for the last 8 years, he's been branded as a murderer, even though he has never shot and killed or intended to shoot and kill anybody at all. I support this bill, and I ask that you all support this bill, because I do believe that if this bill was in effect in 2015, that my son would have had a second chance. He would have been, held accountable for what he did and gave time for what he did at the age of 15, and he will be home with myself and his family now. So I'm asking that you all will please accept Bill 382. Thank you.
Yes, certainly you can.
Ms. Smith, thank you for coming and talking to us today.
Yes, sir.
Was your son and the others who were burglarizing a home, was the home unoccupied?
Yes, sir.
And did your son have a weapon on him, a gun?
Yes, sir.
He did?
Yes, sir.
But he didn't use it or fire it?
No, sir.
Okay. I'm just trying to get, because I'm not familiar with the law, and I'm trying to get in this bill, so I'm trying to get some information on it. So I just wanted to make sure I understood the facts of your situation.
Yes, sir.
All right. Thank you for being here today.
Thank you for having me.
Thank you, ma'am.
Thank you.
Any other questions for this lady at all? Okay. Mr. England? Is there anyone else to speak on Bill 382? All right. Mr. England, let's do House Bill 14 then.
All right. So I'm going to embarrass someone in here today, and I'm going to associate him with me, so I don't know if that's going to help him or hurt him. Okay? It's Senator Brubaker, who's waving in the back. Several years ago, when he was a member of this the legislature, and he wised up and got out of here. He and I worked on legislation together that ended judicial override in the state of Alabama. Judicial override is a very antiquated practice where, even though a jury would impose a life sentence, the judge had the ability to unilaterally overturn that sentence and impose a death sentence. At the time, Alabama, I think, was one of two states that still did it. And he and I worked together, got a bill passed to end that practice. In that same piece of legislation, we also initially proposed for a unanimous jury requirement as well. As you know, the process will sometimes whittle away legislation and put it into a position where more people can agree with it and get it passed. So that was one of the things that was taken out. So as a result, there are still people who are on death row in Alabama who were sentenced life without by the jury, but the judge imposed the death sentence, and they did not get any sort of review or relief when we changed the law. So what House Bill 14 would do would continue the work that Senator Brubaker and I, and also Senator Hank Sanders, who was also carried this bill for years and attempted to do away with judicial override. What it would do is, A, require unanimity for a jury. I know we all may not agree, but it's always been my position that if it requires a unanimous jury to convict, that it also should require a unanimous jury to put someone to death. And the reason why I think that's important is because if we're going to be a state that puts people to death, it should be the absolute hardest thing that we do. And if we require a unanimous jury, it substantially decreases the likelihood that we will send someone who is innocent to death. If we require a unanimous jury, it increases the burden, as it should be, to take a life. And as it stands, Alabama used to be the last state in the country that did not require a unanimous jury to impose death. Florida went back in time and decided to change their law. But for us, a state that says in its constitution that we value life, it's not necessarily a life only when it's convenient. Sometimes you also have to, if your constitutional rights and your belief in humanity matter to you, you have to protect the life when it's inconvenient as well. And what this does is increases the burden. So when a jury or when someone is convicted of capital murder, that same jury has to be unanimous to impose death. So again, that's the bill in a nutshell. And also, cannot forget this part. If, in fact, you were sentenced and a judge imposed your death sentence, this would also open up our law to reevaluate and resentence those individuals that were sentenced by a judge rather than a jury. I know there's a public hearing, so I will step aside and let that begin. Unless there's any
Yes,
questions
ma'am.
for me.
Do you mind repeating that last point you made, please?
Yeah, so if you are currently on death row and a jury sentenced you to life without parole and a judge overrode that sentence and imposed death, this would allow you to be resentenced. Because if the legislature and the state decided that judicial override was wrong and we shouldn't have it in our law, then that relief should be available to those that are currently on death row as a result of a judicial override.
Thank you.
So,
Yes, ma'am. Ms. McClammy.
Question.
yep.
Just for clarification, if I'm not mistaken, you've already passed this in some type of form or fashion previously.
Yeah, again, Senator, wave your hand.
Right.
Again, I'm gonna keep calling you out because I like talking about
I just wanted to ask
bipartisanship.
that question so you could call him out again.
That's right. Bipartisanship, and we actually had conversations about several other things in regards to innocence commissions and things like this. So, if you drew one of those diagrams where the circles go, it may catch us right there one time, right? That will be where we agree. But so, yeah, I mean, it went through an entire session. He was gracious enough, even in that process, to acknowledge that he did not invent this idea, and he actually recognized Senator Sanders and told the world that, Senator Sanders had been carrying this water for a very long time. And it just so happened that, 2010 comes around and wipes us all out, and Republicans took up this mantle, and we were able to work together and get something accomplished, something good accomplished.
And so this bill basically goes back to help those that did not get assistance in the first bill that you offered.
Yeah, and first and foremost, require a unanimous jury, and then also provide relief for those that were sentenced by judicial override.
Thank you.
Okay, Ms. Wadsworth.
Just have a question. If the majority had imposed the death penalty and it wasn't a judicial override, are they resentenced, or is it just a judicial override?
Just judicial override. All right, so let me get out of the way and let the experts talk.
Okay. Is it Mr. Brown? Ms. Brown? I've got several names here, folks. I'm sorry. It looks like it's maybe Ethan or Esther. Okay, please, Ms. Brown.
I'm very honored to be here. I am the chair of the Death Penalty Moratorium Committee for the NAACP in Alabama. I'm also, oh, you can't hear me? Sorry, now you can. Too much. And I am the executive director of Project Hope to abolish the death penalty, the only death row organization founded on death row in the country. What I wanted to briefly take your time up, and I hope it's all right, I wanted to speak about forgiveness because that really enters into everything. Well, a couple of years ago, Antoinette Bosco, the mother of murder victims, who in her book, Choosing Mercy, pleads to end the death penalty, asked me whether I would be interested in writing a piece on forgiveness. I'm honored to call Toni my sister, but somehow at the time, the task seemed overwhelming. There is so much to say on this issue. It was not that I didn't have some very definite ideas about forgiveness, but rather the question was how to express them coherently. There is the issue of closure, which can only come from within. The issue that not to forgive pollutes the love and memory of the one we lost. I speak from experience. The issue that not to forgive allows the one who hurt us power over us. All in of themselves are compelling reasons to forgive, and all ones which have helped me along my path. But then there's also the question of justice, which is the hardest but also the most persuasive reason of all. A little while back, while I was out on a walk and thinking about forgiveness, I suddenly had an insight that the words, "Forgive them, for they know not what they do," were the answer I was looking for. It made forgiveness a question of justice. If the one who offends us did not know what he or she did, how can I possibly, in all fairness, not forgive him or her? I fully understand that many would disagree with me about whether someone knew what they did or not. I am convinced that no one does, not fully. How can I be so sure? Because I know that I can never know fully what prompts my own actions, and that at least I do understand with absolute certainty. Do I think the governor, the attorney general, the warden really understand fully what they're doing when they pursue executions? Absolutely not. They are trapped in their limited cultural ignorance, in their need to please the voter, in their sense of self-righteousness, in short, in their ignorance. The old saying of not being able to understand someone until one has walked a mile in his or her moccasins holds true in this case, as well as in all others. Not only can we not fully understand someone else's actions, but also we can be sure that he does not really, now I've got to turn the page, comprehend why he does what he does either, not with a really deep knowing. Again, I know that for myself. And that is why forgiveness is a justice issue for me. If someone does not really know what he or she is doing, my response cannot be hate. Obviously, those words, "forgive them, for they know not what they do," are not mine. They date back over 2,000 years. For me, they make forgiveness possible. And in closing, I just want to say I'm also a psychiatric social worker, retired. Thank you.
Ms. Brown, thank you. Does anyone have any questions for Ms. Brown?
No, I don't think anyone has any questions.
Ms. Brown. It's okay.
Yes.
I don't see any.
Do you have a question?
Ms. McClammy, do you? Oh, okay. Thank you, ma'am. Ms. Brown, we appreciate you. We appreciate you very much. Senator Brubaker? And Ms. Brown, I'll say this, you spoke an appropriate amount of time. If everybody else that would speak would sort of try to stay about where she is, we would appreciate it.
I'll be even more brief.
Thank you, Senator. We appreciate it.
First, thank you for this opportunity. One of the things that in 12 years in the legislature that I look back on that I'm happiest about is the judicial override repeal. And I did go to Senator Sanders long before the session and ask him if he minded if I carried that bill. And he was gracious enough to let me do it. I would just leave you with two things. The judicial override's already been decided by the legislature. The legislature's already decided it's a good idea to remove the practice. The original bill, it was retroactive. The 31 people that are still on death row through judicial override, the original bill would have removed that. Because of something that happened in the Senate, we were backed up against the budgets, we were running out of legislative days. There was only one no vote in the Senate, and that senator had me over a barrel over time. And he essentially said, if you don't take this amendment, I'm going to filibuster the bill, that's going to kill it. And so that's why the original bill didn't make relief from judicial override retroactive. I mean, that, and y'all are all politicians. You know how that happens. So that's how we got in this position. I don't know, this bill does several things. All of them are good. But one good, simple thing that when it's all over and you're through with the amendatory process, those 31 individuals do not need to be treated differently than all the people from 2000 and what year did we pass that bill? 2018? From 2018 forward. Those 31 people don't need to be the only people who are somehow subject to being subjected to having their sentences changed from life without to a capital sentence. They shouldn't be treated differently. So I would encourage you to treat these 31 individuals the same, make the bill retroactive. The House voted for the bill when it was retroactive, and it was only changed at the last minute in the Senate. And had the Senate been in a position to spend the time and vote, I don't think the Senate would have accepted it. So I would encourage you to go ahead and make this provision retroactive. And the only other thing I would say is this is not a vote against the death penalty per se. This is a vote that says you think jurors should be given the respect due to their deliberations. A jury listened to all the evidence and decided that a capital sentence was not appropriate. And I think we as legislators should respect that. And I hope you'll give this bill a favorable report. Thank you, Your Honor.
Hang on, Senator. Any questions? I got one, Senator. Just
sure.
If it takes unanimity to convict an individual, because the death sentence or the capital murder is a two-phased
right
hearing, and it takes unanimity to convict the individual of capital murder. However, it takes 10 out of 12, is that not correct, to recommend the death penalty?
You have to ask one of the attorneys here. I think it's...
So I guess my question is, of those 31, do you know how many of them had 10 out of 12 or 9 out of 12 or whatever it was?
All I know is
it's different. Yeah. We changed it. At one time, it wasn't 10 out of 12. It was a different number. I just can't remember exactly what it was.
I don't remember what it would. To be honest with you, I don't remember either. But I do know that at the end of the day, the jury recommended life without, and the judge imposed a capital sentence. That's all I know for sure.
Right. Okay. I do too, Senator. Okay. I understand what you're saying. Thank you. Appreciate it. Sorry.
I just wonder, I misspoke earlier. I just made sure, because I want to make sure I'm, fully transparent. Representative Wadsworth, sorry, I didn't want to insult you. When you asked about whether or not it just dealt with overrides, it also deals with individuals that were 10-2. Okay. So it would also give them an opportunity to be resentenced. So overrides and also folks that were 10-2.
Okay. Because 10-2 today would impose a death penalty, wouldn't it?
Yes.
That's what I thought. Okay.
And I want y'all to recognize how much bipartisanship I engage in. I mean, I got decades of it. And I got folks from coming back to this building to tell you, to describe the bipartisanship. So I think I'm a pretty good legislator.
You are aces high with me, Mr. England. There's no doubt about that.
Roll Tide.
I don't know if I'd go that far, Mr. England. Judge Carpenter.
Good afternoon. Thank you for having me. I'm Circuit Court Judge David Carpenter. I'm the presiding judge of the Criminal Division in Jefferson County in the Bessemer Cutoff, what we like to call Bessemer County. I am presiding judge of the Criminal Division. I currently have about 2,200 cases, felony cases, pending in my court. Of those, I have 60 that are capital murder, or manslaughter cases. I have more capital murder cases than any other judge in the state of Alabama. I have never imposed the death penalty. I've been on the bench about 10 years, a little over 10 years. I've never imposed a death penalty, but my predecessor has. On at least 4 occasions, she had imposed a death penalty by using judicial override. And when that happens, of course, a defendant is entitled to a certain number of appeals and to representation while on appeal, and that includes Rule 32 motions. Rule 32 motions are motions that are heard by the original circuit court, not by a court of appeal. So those come to me. The defense attorneys file motions. The district attorney's office has to file response to those motions. I have to review those, rule on them, often set them for a hearing. If I set them for a hearing, that means that the sheriff has to contact Department of Corrections, have that inmate brought from death row to the county jail where they stay until we have a hearing, and then they're sent back. I'm explaining all this to explain to you that this process, it costs money and it costs judicial resources. Now, for all of the other reasons that you've heard as to why this is a good idea to pass this bill, one thing I think you haven't heard is the effect that it would have on the circuit court. It would save us money. It would save us judicial resources. So I encourage you to pass the bill for that reason. But as Mr. England said, if we've determined that the jury should decide what the penalty should be. Well, we've determined they should decide whether somebody's guilty, and they decide that it has to be unanimous. The standard for putting somebody to death shouldn't be less than the standard for deciding whether or not they're guilty to begin with. And if we've decided that we can trust jurors to determine what the penalty should be, then it doesn't make sense that we have people on death row where the jurors did not recommend death, but a judge did. A judge in a political position made that decision. When this bill, the original bill, passed, it took away a bit of power from circuit judges like me. And you will never hear a circuit court judge complain about that. All right? We are perfectly happy with that. This is a power that should be left to the same people who determine whether or not somebody is guilty to begin with. They've heard all of the evidence in the case, and in the case of these defendants that are currently on death row because of judicial override, there's a record of what the jury recommended. So it's not difficult to go back and just go by that record of what they recommended originally. So I would encourage you to do that. I encourage you to pass this bill. Right?
Any questions? Yes, Mr. Wadsworth.
Just one question, and just for my information, you know, a judge has the authority to override a jury, but do they have the authority to, if there's all 12 say death penalty, does a judge have the authority to override that?
Not anymore. They did before this original bill was passed. I can't give you the exact numbers, but I know it didn't happen very often. It was pretty rare. Okay. But the numbers of judges who used judicial override to impose the death penalty skyrocketed in election years. That's the way it was before. It was very low in the single digits, I believe, normally overall as to how often it happened. But in election years, I think it went up to something like 30 or 40%. Over half of the overrides were in election years. So that tells you that there's a political element involved here, and we can take that out. And that political element affected the sentence of these 31 men who are currently on death row. And we have the opportunity to correct that, and I'd encourage you to do so.
Thank you.
By the way, Representative Tillman is my representative, and he appears in court regularly. He knows how busy we are. I just wanted to acknowledge him. So,
thank you.
Thank you.
Pettis.
I concur.
Judge, I have a question for you.
Basically, you're saying the judge don't need discretion in sentencing. Is that what I'm understanding from you?
In death penalty cases, right. We can let jurors make that decision. It's currently the law.
Why just in death penalty cases?
It's the most serious offense, most serious penalty that our system imposes. And I think anything that's that serious, that we ought to have the citizens in the community make that decision and completely remove the political element from that decision.
Thank you.
Thank you.
Any further questions? Yes, ma'am, Mr. Clement, please.
And for clarification, we've already made that change, correct?
That's right.
Okay.
For cases from, I believe, April of 2018, for anybody indicted after April of 2018, when the original bill went into effect, everyone after that is not subject to judicial override. Until recently, I still had cases in the last couple of years where they were indicted before that date, so judicial override still applied in those cases.
So this is nothing that we're trying to start now.
Right.
Thank you.
Thank you, sir. Appreciate it, Judge. Thank you a lot. Ms. Puckett.
Hello. First, let me say I'm scared to death. I'm a nervous wreck. I'm not used to addressing this many people, so just bear with me. Thank you, Chairman Hill, and committee members and representatives for giving me this honor to speak to you all today. This is something that's very near and dear to my heart. About 25 years ago, I was selected as a jury member for a capital murder trial. Robin Myers, we found him guilty, but there's so many things that happened and didn't happen in that trial. I never for a minute thought he was guilty, but I voted guilty, and there's reasons for that. There were, I think, the end vote, we voted several times when we were deliberating. I think the end vote was 9-3, non-innocent, 3 guilty. The 3 guilty were not budging. And we had discussions about this. We were in that deliberating room discussing what we could do. And we were afraid if it ended in a hung jury, then this man would go back to trial again and he may get the death penalty. But we felt like we had power in our hands at the time. We weren't going to prove him innocent because the 3 weren't going to budge. So we decided, since we had the power, that we could find him guilty and recommend life in prison. He seemed to be a good father. We heard testimony. He seemed to be a good father. We wanted him to have a good relationship with his kids. And believe me, it's not easy to sit there and listen to a 10-year-old boy cry and beg us not to kill their daddy, especially when you know he's not guilty of what he was accused of. The state never proved that he was ever on the scene. But this is what we had to work with. And again, it was election year, so, they wanted it done. They wanted the murderer found and prosecuted, and that's what happened. But we recommended life in prison. I'm sorry. And we thought everything was fine. It was over. We went home, and it was 2 or 3 weeks later, one of my fellow jurors called me and told me that the judge had done an override, and he's been on death row for 25 years. This is just a horror I've had to live with. And I know some of the other jury members have had to live with it too. I took it very seriously when I was called to be a juror. They asked us questions, and my comment was, I believe in the death penalty. I believe if someone wrongfully takes someone's life intentionally, I believe in the death penalty, 100%. But in that same comment, I told them, I know our prisons are full of guilty people, full of just, but I also know there's a lot of innocent people in there too. I never in my life thought I would be responsible for sending a guilty man to prison. And especially how we struggled after we heard his son beg for his life. I'm sorry. We went in that deliberating room and we all cried. But we still felt like we were doing the best that we could do with what was given us at the time. And so that's the decision that we made. And I tell you what, and I am honored to be here today to be able to talk to you about this and tell you my part of the story. When I found out that the judge had overturned our recommendation, I was infuriated because why? What was the point of us ever being there if we weren't going to matter? Why did we have to sit and listen to these horrible things? See these pictures that we had to see. He was accused of stabbing a woman to death. I don't understand why we had to go through that for this man to have just turned around. I said, no, it doesn't matter. I know what we need to do. And this man has been on death row for 25 years. And me being here today, if there's anything I have said that would help you all make this decision to make this right, to keep some of these innocent people away from the death penalty, then it was just a gift for me to be here today.
Thank you, Ms. Puckett.
And I thank you all.
Thank you for sharing your experience. We appreciate you.
Thank you.
Mr. Eisner, come on up, sir. You want to speak? You may have a seat. Thank you, ma'am.
Thank you. Good afternoon. My name is Reverend Shane Eisner. I'm the pastor at First Christian Church here in Montgomery, and I'm grateful for your time. It appears that the legislation being considered today contains a contradiction that those of us who support it might do well to address. On the one hand, we oppose judicial override, which allows a single person, a judge, to nullify a group of citizens by imposing a death penalty. That seems unfair, since the legislature removed judicial override years ago but did not retroactively apply the law. This change would undo such inconsistency. However, we also support allowing a single person, a juror, to stop the death penalty's imposition. At present, 2 dissenters cannot overrule a jury condemning someone to die. However, that seems unfair given that conviction requires unanimous consent. Taking someone's life seems just as serious. This change would undo such inconsistency. But which is it? How can one person save a life while another not be allowed to take one? One resolution would be relying on a judge's legal expertise, although some people have already spoken more eloquently to judicial override, so I'll avoid talking about that. However, we also might worry that allowing one juror to impede a supermajority on the jury would encourage more criminal activity. Alas, Governors Bentley and Siegelman published an op-ed yesterday that pointed out that Alabama has more death row inmates per capita than any state in the nation. However, the CDC states that Alabama has the nation's 3rd highest murder rate per capita. We sentence certain criminals, we execute them, and yet still we generate more than anywhere else. By continuing that, it feels to me like trying to out-recruit Nick Saban. Just don't keep doing what ain't working. With apologies to you Auburn fans. As a Christian pastor, my resolution is this. I appreciate this bill establishing laws that encourage consistency and fairness. However, I also appreciate that this law balances justice with mercy, punishment with dignity. That balance seems righteous to me. After all, Jesus commanded his disciples to love their enemies, yet not pretend they're friends, to pray for those who persecute them, but not let them off the hook. Turn the other cheek is about resistance, not acquiescence. And as a victim of capital punishment, his death pays witness to at least one universal truth, that just because someone can do something doesn't mean they should. The Romans, of course, could kill Jesus, but that didn't make it right. And just because y'all can do nothing here to make our death penalty regime more consistent and decent doesn't mean that you should, to my opinion. You each have the power to make our state better by supporting HB 14. Thank you for your attention, for your public service. May God's wisdom bless us all.
Thank you, Reverend. Appreciate it. Any questions? Okay. And the last individual to speak is Tony Hall.
Thank you, Chairman Hill, and thank you to all the representatives on the committee for permitting me and my uncle to speak with you today. My name is Tony Hall, and I am here today with Helvetas Hall. The issue addresses in HB 14, the unanimous jury requirement and the judicial override retroactivity could not be closer to our hearts. On October 15, 1994, my mother and Helvetas' sister, Faith Hall, was murdered by Joe Nathan James. Faith was a loving and supporting mother and caring and dedicated sister. Faith's murder was a tragedy, and not a day goes by where we don't miss her. I don't think it will be a surprise I don't think it will be surprise any one of you to hear that. For a while, we hated Joe James. We could never understand why he did what he did, why he stole Faith away from us. But as more time passed, our feelings changed. Today, although we still do not understand his actions, we have learned to forgive him. When it came time for the state to set an execution date for Mr. James, we pleaded to Governor Ivey and Attorney General Marshall to stop the process. Executing Mr. James would not help heal us, and it would not bring Faith back. It would just be another senseless killing. No matter how many letters we sent, statements we made, or news outlets we spoke to, Governor Ivey and Attorney General Marshall refused to listen to us. Our voices were ignored, which brought back much of the pain that we felt in the early days of this tragedy. Now we've never sat on the Capitol jury, but we're speaking with you today because we know just how it feels to have your voice ignored and overlooked on such an important issue. It is a jury's job and the jury's alone to sentence someone to death in Alabama. And this legislator agreed a few years ago that judicial override is no longer appropriate. It realized that we must value the voice of our jurors and trust their judgment. It does not make sense to continue to ignore the voices of the jurors who voted for life sentences and capital cases before 2017. We need to right this wrong. We retroactively correct the old judicial override verdicts. Likewise, everyone in this room knows that a life and death verdict is the most important decision that a jury in our state can make. It only makes sense to listen to every voice on the jury, even those in disagreements to the majority, and enact a death sentence only in unanimous cases. With that jurisdiction committee, we urge that you pass HB 14 to give us the voice and the voiceless the rights to the voiceless and right the wrongs of the past. Thank you.
Thank you, Ms. Hall. Appreciate it. And ladies and gentlemen, that concludes the Judiciary Committee for today. We thank you for coming, and we look forward to seeing you later. Yes, ma'am, Ms. McClammy.
Judge, Chair, I know this may be out of order. I know usually when we have these public hearings, we listen today and we come back the following week and discuss a little bit more openly. But due to the fact that this is the 25th day of our session, due to the fact that we've had so many people come here today to speak with us on this matter, due to the fact that this is not any type of real new legislation that we're dealing with. We're talking about some correcting a wrong or something that took place where the simple words of retroactivity did not be included in a bill. We're looking at, we've left 5 years going already with 31 individuals who may possibly have the opportunity to have life outside of prison. It just does not seem as though this bill and this public hearing would be seeing justice, in my opinion, if we come back and say, thank you for coming, we hear all you have to say, but us sitting up here knowingly know that this would not be something that we would have an opportunity to go through this session.
And that may be true, Ms. McClammy, and I appreciate what you're having to say. However, we've always run things on a procedure, and when we get bills, we try to give the members of this committee an opportunity to consider that which we've done. You know just like I do that sometimes these bills take years to work through this system, and I do appreciate that. And I've worked on them for years, as have you. However, I don't think we should change the procedure that we have at this point in time. But I do appreciate your concern. Thank you for sharing it.
Thank you.
Ladies and gentlemen, we're adjourned. Thank you.